They have just started to debate the charter school bill in the Senate, and so Representative Carter couldn't be here to present the bill. And so since I do not consider Michael O'Sullivan, who works for the Secretary of State, to be a lobbyist and who has worked on this bill through all of its changes, I'm going to let Michael present the bill.
Thank you, Madam Chair and members of the committee. We're working off of LC 334744S.
68.
That's Senate Bill 368, yes, ma'am. Senate Bill 368 is several components of some legislation that was first requested by the Georgia Board of Nursing. It does numerous things that are have been requested for quite some time. The main portions of which are continuing education, or as the legislation and the board refers to it as continuing competency for nurses. Nurses are the only health field under the Secretary of State's office that does not require continuing education, and one of only 10 states in the entire country that do not require continuing education of nurses. Another portion of it, Section 2, deals with allowing an inactive status for these nurses that are not currently practicing but would still like to hold their nursing license. You can place that on an inactive status. This is commonplace for licenses that have a continuing education component. And Section 3 is a mandatory requirement, mandatory reporting requirement for nurses and for employers of nurses. Essentially, if you are a nurse or you're an employer of a nurse and you have found or have information that a nurse has violated the Nurse Practice Act, and we've specified in the code what those items are. If you found that a nurse has violated the Nurse Practice Act, you are required to report that to the Georgia Board of Nursing to be investigated. It doesn't mean that that nurse essentially will be disciplined, but it will be investigated. There has been instances where a nurse has violated the Nurse Practice Act through drugs or alcohol abuse, in which that an employer would simply just fire the nurse and rather than get into any issue. And so the nurse would then go to another employer and then to another if they get caught. And so this would stop that. Again, this is a provision that most states have. I believe it's 41 states and territories that require this of nursing, and is nothing new. I would also like to say that we have worked very closely with just about every entity that would be affected by this: the Georgia Nursing Association, the Georgia Hospital Association, individual hospitals, our office and the board, and all of us spent many, many hours going through this and fine-tuning it to a point where I believe everyone is of a strong belief that we've got a good bill that protects patients, that protects nurses, that protects employers, and will lead to better care. And so that is 368 in a nutshell, and I'm very happy to answer any and all questions that may arise.
Representative Henson.
Thank you. I do have a few questions. This is supposed to be for continuing education requirements?
Yes, ma'am.
Excuse me. It looks like, and I've worked in other CE requirements for many, many different professions, and we'll even go to cosmetologists and everything. This looks like the only one where you really don't have to take CE requirements, that you can do a bunch of other things in lieu of it.
Yes, ma'am.
You could even work for 500 hours instead of taking CE credits. Is that correct? Under Section 4, line 26?
Right, not entirely correct. It is a little different, and I will grant that. What we have done here, and if you were to look, our language, essentially the Georgia board was looking to have this requirement on their own and didn't have the statutory authority to do so. What you have and what you see here is what they were looking at requiring, what the board was looking at requiring, and it's also what you would find in South Carolina. This is almost exactly how South Carolina's is. if you look through the types of continuing education, you've got 30 hours of continuing education, which
Yeah.
is very standard. A maintenance of certification from a national certifying body, which is, they have their own standards. So a nurse that has a higher certification, they have their own continuing education standards. Completion of an academic program. So if you complete it during that licensure period, you are essentially doing things to train yourself to the newest and latest standards. Number 4 is a verification of competency, and it's limited to facilities under Title 31 and part of health systems. Essentially, these are certain hospitals are accredited in certain ways to meet licensure and would put their own employees, their own nurses, through continuing education requirements. They are required as part of their licensure and required as part of their accreditation to have continuing education. And the issue that was brought up was if you've got a hospital that's in existence that already requires much more than 30 hours over 2 years worth of education that is goes above and beyond what would normally be required of this, that should count for something, and we tend to agree with that.
I understand, and I hear everything that you're saying, but it's like, it's very different than what a physician or a dentist or someone else would have to do. I mean, they have to do CE hours no matter what else they do. Why are we not requiring CE hours regardless of what else, like Section 3? It's an academic program of study,
Right.
or related field, but it's...
Well,
I mean, I understand that in a manner of speaking, that is like 30 CE hours.
In a manner of speaking, a hospital would require their nurses to go through much more than 30 hours.
Yeah.
And that's what is attempting to be captured here. Again, it's, as it says, as evidenced by employer certification on a form approved by the board. Essentially, as the board imagines it, they would say, these are the following, here's the form, please list out the following educational requirements that this individual has met. And if for whatever reason the board is to find that people are using this as more of a loophole than of actual certification, then that would be dealt with. We don't want it being abused. But that being said, again, the hospitals have assured us, and that's who's trying to be taken care of here, is that those that already have certification requirements, educational requirements that are top notch would actually get credit for that. And again, this language is usual across the nursing field for other states. Again, we took this almost verbatim from South Carolina.
Thank you very much for your
Absolutely.
explanation.
Yes, ma'am. Thank you.
Okay. Representative Kidd.
Thank you, Madam Chairman. I think you're saying here that if a nurse doesn't keep their license active for a number of years, they can come back and I know you got like 20,000 nurses in the state, but only half of them are probably practicing nursing, and the rest of them are at home married to doctors or whatever. But whenever they get divorced later on, and she has to go back to
Or
work.
working at the legislature.
She has to go back to work, and it's been 10 years. Then all they have to do really is come back and pay the initial fee again and take a little small course, because they've been out of it for 10 years and hadn't had any continuing education for 10 years.
Right. If you look at Section 2, Part B, which I believe is line 50, the board shall require evidence of competency to resume the practice of nursing as a registered nurse in order to resume and to restore the license to active status. And thus, if it would kind of be determined on the situation. If you've got a nurse that has put their license on inactive status because they've moved to another state to practice as nursing in another state with the intention of eventually coming back to Georgia, that would qualify. If you've got a nurse that is in the Army and has been transferred to Afghanistan for several years, they can put their license on inactive status and come back and without any requirement for additional evidence of that would be the evidence of competency. However, if you've got a nurse that has been for 10 years, just had their license on inactive status, and then decide that they'd like to try it again, that would be the situation where they would be asked to either do some sort of reinstatement process or just come up with the continuing education depending on what they did and how long they've been gone.
How many years can they be gone without having to take some type of competency?
That would be a determination by the board of just, it would depend on what they did and what they know and
Okay.
you know, any of that. You know, yeah.
Michael, can I ask Deb Bailey to answer some questions for us? Deb, will you come forward, please? On that point. Don't go away.
Madam Chair, members of the committee, I'm Deb Bailey, and I am representing the Northeast Georgia Health System. I guess maybe I was asked, I am a nurse, and before coming down here was the Vice President for Nursing at the Northeast Georgia Health System, so.
I have a question.
Okay.
Okay. When nurses have been out for a period of time, what does the Northeast Georgia Medical Center do? Isn't there a 3-month or some course?
Currently, the law is that if you have been out greater than 5 years, you take a refresher course, and that has to be a course that's approved by the board, and it's rather lengthy.
In the 3 to 6 months?
Yes.
It's 3 to
yes,
6 months.
Both, and it's both clinical and didactic.
And clarification for the committee, what kind of courses, continuing education courses, do you offer that are required to meet certification for the hospital to your nurses?
Well,
some topics.
Okay. That really depends on your specialty, because the critical care nurses, the recovery room nurses, the emergency room nurses, the neonatal intensive care unit nurses, all of those nurses in every specialty have very specific requirements that are beyond all of this. In addition to, there are CPR courses, there are advanced CPR courses, and then there are numerous. There's an average of about 40 to 60 hours that are required for the staff nurse on a med-surg unit. But then in addition to that are all of those other courses that we would talk about. So on average, they get about 60 to 80 hours a year.
Okay. Are there any questions specifically to Ms. Bailey? No? Thank you. I'll go back to, right, okay. Representative Dodge has a question for you.
Thank you, Madam Chair. This is about another issue, and so whoever wishes to answer,
Okay.
unless someone had a question about that. It didn't look like there were.
Well, I have a list. You want to get on the list?
Okay.
Okay. Representative Kidd.
I was through,
okay.
Madam Chair.
Representative Rogers. Sorry.
Yeah. Deb, one of the 30 hours, nurses work such odd hours anyway and long hours. Why did the board come up or recommend 30 hours of continuing education?
I think 30 hours was the recommendation based on all of the other states that we looked at in coming up with these recommendations. So that was.
Are y'all hung up on 30 hours?
I think the board was. Hospitals weren't.
Board's not here though, right?
Michael is representing the board.
You're not
I
a
think.
nurse, are you, Michael?
No, sir.
Okay.
But
I would say that the 30 hours is
30 hours is a long time.
it is, but again, you were talking about their schedules for a nurse that is essentially working and being employed in a hospital setting. They would most likely fall under that the number 4 category, the verification. And again, that's 30 hours over 2 years. It's 15 hours a year. So in that case, it's not that long.
And Representative Rogers, that is one of the choices they have. If you look, each of those that's 30 hours or the maintenance of certification or recertification, or so that's the choice that the nurse has in
I understand that, but
renewing her license.
But when the board does their rules and regs, and the nurse has, or LPN has no other choice, isn't that
It's an
correct?
LPN.
She has to choose one of these 5 categories to renew her license, and a
Okay.
license is for 2 years. So as he just spoke, it would be 15 hours for each year,
Okay.
the way this is written.
And
All right.
Representative Rogers, the LPNs have been removed from the bill. They should be required to have continuing education, but it was, their board is not ready to set it up yet, so I think we'll be back with one for the LPNs.
So it says LPN on line 62, so you're saying LPN's been removed?
The RNs are in the continuing education competency. The LPNs are in the mandatory reporting.
Okay. Can I follow up with one other question, Madam
Certainly.
Chair?
Mhm.
I was looking at lines 120 through 125. Why does that need to be in there? Minor incidents? What would be a minor incident?
This language, the mandatory reporting requirement essentially is the model act as brought to you by the National Council of State Nursing Boards. A minor incident, this is one of the areas that they've added in. Essentially, if the board were to find that there's instances in which people are being reported that they wouldn't necessarily deem to be a safety issue or a violation of the chapter, or a issue so minor that it's not worth dealing with, or that would be better served being dealt with by the employer, that the board has the ability to create a rule that essentially says this issue doesn't necessarily need to be brought to our attention, and they could put a caveat on it saying that so long as it's been dealt with by the employer.
But my question, why is it even why do you need that?
For clarification.
Because South Carolina does it, or?
It's because it's part of the national model act,
Okay.
and it's just one area that
What is a minor accident or incident?
Rogers, if you'll let me answer that, I think it could be something if you have a nurse that is has been reported several times for inappropriate language or inappropriate.
Flirting?
No. If there's inappropriate sexual activity, that's a major thing. But maybe they have a really bad temper and they're reacting with patients in a way like that, and they get reported to their supervisors. This is clarification. Deb, you got another one?
I think the real point was to make sure that they were only getting the major
problems.
issues.
It is clarification.
And so it's not that we were trying to clarify what a minor issue is, but that only major issues are reported to the board. And major issues are usually those issues that are drugs in the environment, in the nursing environment, which has become a major issue for many employers now, and those types of things. That's what this is intended to get.
But isn't it true though, Deb, if I don't like a nurse, I can file a complaint against the nurse?
That is true. And
it could be an incidental act,
mm-hmm.
but the board still has to investigate it as an incidental act.
They do now. That is current law, and the board does look at every single issue that's reported to them.
So if I'm a nurse, or Madam Chairman, if you mind me following up.
Sure.
So if I'm a nurse and a nurse tells me I'm the nurse and I'm not, she's the nurse or he's the nurse and I'm not, then I can file an action. So the agency, the nursing board, still has to investigate that incident, correct?
That's correct.
Representative Rogers, if it helps any, right as we started this session, I got a call from a stepfather who has 3 little stepsons. And the father of these children had just OD'd. He had worked as a nurse anesthetist and had been caught shooting up heroin in the surgical unit. And the hospital had just let him go. And he managed for 2 years through friends to get small jobs in little places. That's what this is what it's looking for. And this is more toward the reporting. Certainly could be individuals, but it's more toward the employers, that they must now report. Anybody can report, but this is directed more toward the employers of the nurses. And I think the minor thing is just trying to clarify that they don't have to report every incident, like if there is something with nurses that don't like each other, that they have the discretion to decide that this is minor and not a major incident, and it doesn't have to be reported.
All right, Madam Chair,
As
if you
best
go
I
to
know.
if you go to line 111, doesn't that address what you're talking about, though?
Do you want me to answer?
Yeah, go ahead. It does.
Representative Rogers, it doesn't. What Madam Chair is speaking to is, as an employer, and we have an issue with a nurse that we suspect is using drugs. My organization specifically will address that. We will try to do an intervention.
Right.
Lots of times there are institutions that will just either fire that nurse or let that nurse, the nurse gets wind that she's going to be fired, and she quits, and she leaves and she goes to another place, and then another place and another place, and there is nothing in current law to address that, what should be done with that nurse. And this is trying to address that, saying that now, as an employer of that nurse, you are required by this law, should it pass, to report this to the board. Now, the board will have a lot of leadway in what they do with these type nurses. And of course, there are lots of things in place, particularly for those that are abusing drugs. That example, lots of things in place to try to help these people, not just take their license away from them. That's not the point of the law. It's just to report it to the board, and the board will make the decision of what is done with that individual. But
Okay.
it is for the safety of the patients.
But doesn't line 11, 12, 13, 14, and 15 address the drug issue, Madam Chair? And then I'm just trying to define what a minor incident is. I wouldn't call a convicted of a felon, moral turpitude, or drug abuse be a minor incident. Isn't that true?
You would call it, no, that would be a major incident that
Well,
they'd
that's what I'm
have to
saying.
report.
Yeah.
But, pardon? Representative Watson?
Yeah, I mean, and this may or may not apply, but for medical licenses, I mean, they do list that if you've had a traffic ticket, then we don't have to report that. But if you get a DUI or anything else besides that, that is reportable. I would presume that's what that's alluding to, and council may be able to help us out with this, with that. But a traffic ticket, in my opinion, would be what would be the
That would be
minor
one of
offense.
the things. Yeah, go ahead, Betsy.
We have to, traffic tickets are the only thing that we do not have to report on a medical license for renewal.
Okay, Betsy.
Yeah, I think one thing on line 124 and 125 about investigating something that ends up being a minor incident, under this language, in my reading, and Michael, you can think, is that the board would not have to investigate it if they initially look at it and say this is a minor incident. And I'm just trying to think of examples also. One of the things that they can't do is represent themselves to be an RN. Maybe their license has expired and their check bounced or something, and they said they were an RN. Well,
That's right.
that's maybe, it could turn into a problem, but maybe that's just a minor incident. They get it cleared up. That's not a reportable. I'm just, noticing. But anyway, so it would allow the board to set some criteria so that employers and fellow coworkers of the nurse aren't
take care of it after? Okay.
Good.
Okay, go
I
ahead.
actually had a question, just for point of clarification. It says on line 18, and it goes through, one of all the other things. Is the cycle, is it a 2-year cycle?
Yes.
Okay, that will help clear things up. And if I could just follow up with Representative Rogers, so it's going to be 30. A nurse could choose to do 15 hours 1 year, 15 hours the next year. I mean, and it's relatively easy to get these continuing education. I mean, most of that's done online at their leisure when they want to do it. And
Yes, or provided, if they work for a large organization, it's provided by the organization. And it just requires that 30 hours within that 2-year period.
so you could do them
not
all.
15, yes.
Right, you could do all 30 hours 1 year on
you're good.
online,
Mhm.
and you got it done.
Representative Pack.
Thank you, Madam Chairwoman. Quick question. Why was there a need for the continuing education requirement? Did you have problems with incompetent nurses coming back into practice?
Michael?
I wouldn't necessarily say that there would be a problem that has come to our attention, but it is the only allied health area that there's not. There is a population that had not been utilizing their license for several years and are now, because the economy, gotten back into it, and obvious concern about whether they are up to date on the latest practices in CPR or HIV, and any number of different criterias.
And the reason I bring that up is obviously law and medicine have CLE requirements and all that. I'm afraid that imposing a 30-hour continuing education, which probably they need to pay, right? It's not the employer paying; it's the person wanting to get their license back, right? Wouldn't that discourage?
It is incumbent upon the person getting the license, yes.
And from what I recall, at least in legal
Yes.
CLE, this is not cheap.
Yeah.
So wouldn't this discourage nurses from coming back into practice?
I would not think so, because right now, as he just spoke, those that have been out of practice now for 5 years are back taking the 6-month course, trying to get back into practice. So, and again, that's just one of the choices that they have, one of the many choices that they have to renew their license.
Okay. May I follow up, Madam Chairman? The second issue that I have here is the reporting requirement starting in 66 on. And in conjunction with the immunity clause you guys added on the line 131. I mean, setting aside for a second, whether or not it's a good idea to force them to report. It says shall report, so it requires them to report. Then if you look at 132 to 135, and similar to, it says, no person in good faith either reports or fails to report shall be subject to civil or criminal liability or discipline. So there's really no teeth for enforcement. Am I wrong about that?
Well, this is what we were trying to accomplish with that. Basically, the same nurse that I discussed before, that we think maybe that she has been either taking drugs or abusing drugs on the job, and she knows she's about to get caught, and she leaves. Or maybe it's a person that someone just thinks because of her behavior over a number of Monday mornings that there's some issue, and she quits the job and leaves. So we as an employer say, well, okay, we thought that this person was maybe doing something, but she really has left, and we do not want to be responsible for reporting if they leave beyond our ability to determine that.
The main idea being that a employer can't be held to civil or criminal liability if they didn't report something that they didn't believe to have happened. So if they had no idea that a nurse was abusing drugs and thus had never reported that particular nurse, because they had no reason to believe, they would not be held liable for not reporting that because, again, they had no reason to believe. However, if they did have reason to believe and they did not report it, then you have violated both sections, because this, in 432655, it says that in good faith either reports or fails to report. So thus, in good faith, if you had reason to believe and you didn't do it, you are in violation of the code.
I understand that, but how would the board know to investigate whether or not they acted in good faith without someone telling them this?
Well, again, this area would be subject to criminal liability or discipline.
In the scenario that you described.
Well, I think probably in that scenario that I would be employer number 4 down the line, and I would look and say, and I realize this person has something that I'm going to report, and I kind of look back and said, they worked at 3 other places before they got here in the last 9 months. Now, I wouldn't have hired that person, but that's the scenario.
Are they required to report their previous employer?
On the application.
On an application, they are.
Okay.
Representative Dobbs.
Thank you, Madam Chairman. My question is regarding the same provisions on line 67 through 69 regarding the requirement that a nurse actually report another nurse for violations of these specifically listed items. And then, is there a penalty for not doing so that's listed somewhere, or is that going to be handled by board regulation or on an individual basis?
I would suspect that would, if you knowingly know that that a fellow nurse is in violation of the code, you are currently not carrying out your responsibilities as a nurse. So, you should be, as a licensed professional, be reporting someone that you know does not is not violating it. The area that this that is making it explicitly clear that a nurse shall report the names of individuals to the board that has reasonable cause to believe that they've essentially violated the Nurse Practice Act.
So what's going to happen to them if they
Well,
don't?
it would be determined by the board as to what the penalty would be. I would suspect, based on how much they know and what the severity of the crime was. If you knew of someone that had a minor incident and you didn't necessarily report that, I would suspect that they'd look at that, one way. Whereas if they looked at someone that was shooting up heroin in the operating room, they'd look at that quite a bit differently.
So it'll be just handled like a disciplinary action?
It would be handled just like it normally would, yes, ma'am.
All right, Representative Brenner.
Thank you, Madam Chair. I'm sorry I came in late from another meeting, so I missed the introduction of the bill. And the bill is extensive. It's a 5-page change in the law, and really the gist of my question is, don't you have a board that regulates you?
Yes, it's the Georgia Board of Nursing, yes, ma'am.
Then why can't the board, by regulation, actually do the things that you're asking the statute to do?
They attempted to. That's the crux of the bill, is they attempted to do so, but was informed by the Attorney General's office that they didn't have the statutory ability to do so, and that a legislative change was required.
Interesting. Thank you.
Representative Kidd.
Let me see if I can help you just a little bit on the answer. It's the duty of every medical practitioner, nurse, doctor, dentist, et cetera, to assure to the best of their ability that all patients are always taken care of to the best of the ability of anybody who's licensed. And so as an employer, a lot of times when we have an employee who's not up to par, we let them resign rather than be fired, so it won't look as bad on their record. But in the healthcare area, you're trying to get the responsible party that does the hiring to notify you because that person is liable to go be hired by another practitioner down the road and could cause harm to a patient in that office. And so you put this language in 131, 130, down that area, to try to entice the employing physician, whoever it may be, to notify you to protect future patients in other people's offices down the road. Is that not right?
You nailed it.
Okay, that's what I thought. Thank you.
Well, and I think one of the things to Representative Kidd to that is that employers have become afraid of lawsuits if they report to the next employer. So they just will write a very bland, if anything, and afraid to really say what went on because they're afraid of a lawsuit. And unfortunately, that has certainly hampered our ability to know the people we're hiring. Representative Rogers. Okay. Other questions for the presenters? Oh, okay, go ahead, Representative Beverly.
Thank you. My question is more along the line of Representative Henson's question. When you look at the requirement, the OR requirement for 500 hours, it basically translates to about 3 months, a little over 3 months, that a person has to practice. But if you stretch it over a couple of years, you're talking about a nurse has to practice basically an hour a day.
That requirement, it's a verification of competency and at least 500 hours practice. So essentially, over that 2-year period, what you're trying to capture is a practicing nurse rather than someone who is not. 500 hours is the number of hours that's needed to maintain.
Right. But the 500 hours, to me, appears to be a part-time nurse. I mean, that is not a lot of time when you think of the course of a 2-year period. You're really actually talking about someone could work 5 hours a week, and you're considering that person competent, but it doesn't necessarily mean. I mean, that's a very minimal requirement over a 2-year period. And so the continuing education, from what I understand, gives you an opportunity to actually catch up on the latest technology that happens in your particular field, and those hours are extremely important. Even if you are practicing every single day, those new technology, new techniques, and so forth come out all the time. So a part-time practicing nurse being exempt from that doesn't necessarily go to the competency issue. I'm not sure how you reach that with 500 hours.
Well, it would be the competency is in addition to the 500 hours. What we have found in nursing is that we have a lot of part-time nurses. A full-time equivalent is 2,080 hours per year. And we have very few of those. Now we have weekend shifts where someone works just weekends. They work 12 hours on Saturday, 12 hours on Sunday. And then we have other kind of part-times. It's probably one of the most flexible jobs that anyone could have. I think that's why we have like 5-year waiting lists for those positions now. But I think that was what we were trying to accomplish with that.
Questions? Okay, Representative Rogers.
Madam Chair, let me ask you this. A nurse, they surrender their license according to lines 36 through 40. And that's only for 1 year, isn't that right? If you surrender, then you have to reactivate your license?
Yes, again.
If you
There's not a 2 or 3 year window waiting. You have to do it to reactivate. Is that not true? You have to you do it within a year.
But the board has very specific rules in place based on what the issue was, that the board will require certain things before that individual gets a license again, if they're able to get their license again. They don't automatically get a license in that period of time.
But if you go inactive, how long can you go inactive by the board? Is there a period of time you have to go inactive and then activate your license?
You could go inactive for as long as you'd like. However, if you're longer than 5 years and you aren't practicing nursing in another state or doing something in that regard.
But according to this language, then you have to come back to the board. They don't come to you to notify you.
That is correct.
So the board will not notify that nurse is inactive if she or he are out of state. It's up to the nurse.
Correct.
Okay.
If you come back into Georgia, that's when you.
Maybe Senator Carter can shed some light on some of this.
Representative Carter, since you weren't here, we were trying to help you, and Senator Carter, we knew that there was an important bill being debated, so do you have questions for the senator? Ed?
Thank you, Madam Chair. My question is relative to a similar subject matter that was probably more germane to the original Senate Bill 368 than it is now. And that is the bill that you passed in this committee, House Bill 1143, passed this committee unanimously, that dealt only with continued education hours for licensed orthotists and prosthetists licensed by the medical board. And I know I talked to you briefly about this, and it might be ruled germane, it might be ruled not germane, but I hoped it would because it could be added to this bill and possibly go on through.
Betsy?
Yeah, my concern with this is, you're right. I think originally when it was just continuing ed, you could make a logical connection between the two. But as you all know, there's a constitutional requirement that each bill only has one subject matter. And now that the bill is kind of going out into regulations generally of nurses, then to add that, in my opinion, gets beyond the single subject requirement. It's, obviously the will of the committee, how you want to proceed, but that's my.
I understand. I just had to bring it up.
Thank you, because that's my bill, and I would, of course, love for it to go somewhere, but I don't want to do anything to cause a problem with this bill. Representative Rogers did. Representative Watson, clear up any question you had?
Madam Chair, the problem I have with any licensing boards, it's up to the nurse to notify the board to reactivate a license and go through it. So many times people, no matter what profession there is, their time runs out. The board doesn't notify them, then they have to go through the entire process again. This has happened to me before, and I think it'd be better to have language that the board notify a nurse that's inactive just to put them on notice. If we don't, there's going to be I can see a pushback.
Well, I would say that currently those people that are licensed now are notified each 2 years when their license is to be renewed again.
Yeah, but I'm talking about the inactive part of it. If you go inactive, say 2 years or 3 years, Deb, and your time limit's up, then you have to go through the entire gamut of continuing ed.
I think the concern from the board on something like that is there are 100,000 nurses in Georgia that are licensed, and I think they haven't been able to manage those kind of volume issues.
And Representative Rogers, if you choose to go inactive, it's a choice by the nurse, and that inactivity would continue. I mean, now, if the board would have the right to charge for that.
They do.
Okay, that's right. So you would be notified if they decide that to have an inactive status every 2 years you pay $25 to continue that. You would get that notice like you do now. I mean, I haven't been in the hospital in quite a few years, but every 2 years I get a notice from the Board of Nursing that it's time to renew my nursing license.
But the ones that are inactive do not.
But I believe that the board will, there's no inactive ones now, but I believe the board will charge you some minimum, is this what
No, that's right. A nurse can voluntarily place themselves on inactive
Right.
status for the period that they are inactive, and when they would like to come out of inactivity, that is the point that they would because obviously they are aware that they're coming out of inactivity, and when they place themselves on inactive status, I would suspect that part of that process is you are inactive. When you return to nursing, if it's been longer than 5 years, it may require additional
Yeah,
competency.
but my point is, the board does not notify, the Board of Nursing does not notify.
We wouldn't.
So if you go past 60 months, you start over again, period.
It would again, it would depend on what you've been doing during those 60 months. If you've been
Right.
practicing nursing in another state, you
Right.
probably wouldn't have to do anything.
Yeah. Well, you could be a lobbyist, or you could be a state representative or state senator, and you miss the date. That's what I'm looking at. That happened to me, and it only cost me $5,000
Oh.
if I chose to pay it, but I chose not to pay it. So
Representative Rogers,
That is in place now. I mean, there are still people that, even though they get a notice and they are not inactive, but they do forget
right.
to renew their license. And I think for nursing, it maybe is like $100 or something like that. It's not
Penalty.
something.
well, and does the board plan to charge
Oh yeah.
an inactive fee? Is what I'm saying. If they charge an inactive fee to have an inactive license,
It'd be more than 44 cents. I can assure you that.
well, and they would be doing it every 2 years.
Yeah.
Essentially, any fee that's charged goes towards the cost of whatever the service would be. So, however much it would cost us to run that service of processing that, I wouldn't expect it to be minimal. Again, all fees go to the general fund. They are not maintained.
Michael, do you know? I know we don't have any inactive nurses now, right? With the Board of Nursing.
That is correct.
Is it a hardship to put language in there that they notify an inactive nurse after?
Well, again, we wouldn't. Once a nurse would supposedly go inactive, at that point it stops being a concern of the board, either where they are or what they're doing. So,
But what I'm referring to, if they wanted to reactivate their license, if they got a 12-month notice, a 90-day notice, or 180-day, is that too hard to do?
we wouldn't have any idea of when they would be intending to reactivate their license.
The inactivity, Representative Rogers, would just continue indefinitely.
Well, that's what I'm saying, but I heard Deb say a 5-year, didn't you say 5 years?
That requires a refresher course. If
Right,
you have
that's what
been-
I'm referring
If you have
to.
not been practicing nursing for 5 years, then it does require a refresher course.
Right.
Which you do have to pay for, and is
Right.
it's rather expensive and very time. With some,
And it's current law.
it is current law, yes.
Okay.
Okay.
Anything wrong with that, Madam Chairman?
Wrong with what?
Putting a notification, they just notify an inactive nurse
I think you're
in a
asking,
timely manner?
are you asking if
Before the 5 years,
Yeah.
so that they could come off inactive status before the 5-year
That's what,
point.
and I'm using me as an example. That's what happened to me in another profession, and it was up to me to do so. I mean, 5 years is a long period of time, and keeping up with a date.
I mean,
A
that would
courtesy email or courtesy card or not a phone call, but
I mean, Representative Rogers, I think that there's 110,000 or more registered nurses, and if you had, I don't know how many nurses.
you don't have any inactive right now.
No,
though.
but what if you had 20,000 that go inactive, and they go inactive at different times? How are you going to know when that 5-year is up to send them a notice so much,
Can I refer to legislative council for language? Betsy, is there any way to fix that notification?
Well, I think we were addressing it, but if they, for instance, have gone to another state and are practicing nursing, then I'm not sure how we, how the board can know that unless you just.
Can we not?
The date they go inactive, decide that years from there, regardless of what they do.
I think it'd be safe to put language in before the 60 months.
The board would just notify that nurse that they are coming up
Correct. And it can be done electronically if they've got the
For a
correct
period of
email
5
address.
years. And you can make inactive status just a 5-year.
Would that be okay, Madam Chair?
It's certainly okay with me. I think you're handing the board a nightmare and looking for a
Well,
problem that,
I'm looking at the consumer nurse or any consumer. It happened to me, and the cost was $5,000. So I said no. So I think a board can do it. I think all the boards can do this, and I think that's the direction we need to send nursing board or any other board. So
okay. We'll entertain a amendment and see how the committee feels about it. I will let the amendment be presented. Oh, Representative Kidd, you had another question?
Yes, ma'am. One last question, and I'll be quiet too. And I'll even make a motion, want me to. But obviously, the hospitals have training programs within the hospital to retrain nurses or bring them up to snuff, so to speak. Does that also permit closed shop HMOs and so forth to have nursing education programs within the closed shop HMO?
Actually, if you're talking about after the 5 years for these people to come back,
No.
Are you talking about
in general right now? You know, if someone's out or someone's in, and the hospital provides some continued education hours. Your hospital does. I think you said your hospital provides continued education hours. Is it permissible for a closed shop HMO have continued education hours?
I think so. Not unless they fall under that title of the law.
if they fall into one of these 5 categories.
Obviously, a closed shop is one that's not open, but is restricted from the number of people coming in and out all the time, as you well know. You know what I'm talking about, the closed shop, the HMO. It's different than your hospital. It has a hospital, and doctors' offices are involved, and you got nurses that work for the doctors' offices in a closed shop HMO, which is totally different than the doctor's office that your hospital has in your hospital. I was just curious if they were treated the same way.
Those nurses are allowed to choose between 1, 2, 3, 4, or 5 for renewal of their license.
So I guess if it's a closed shop, it'd have to be, excuse me, if it was a closed shop, the closed shop HMO program would have to be approved by the board, then they could offer it. Is that right?
That could be the case. The board would have that leeway depending on what continuing education that employer is providing.
Yeah, I was just looking at number 5, other activities prescribed and approved by the board.
Absolutely.
The board would have that discretion of looking at what educational opportunities they provide.
Thank you.
Okay. Other questions? I will say to the committee as we wait for the amendment, I think there raises a problem about how we will verify that the board has tried to reach the person at 5 years, and how and at 5 years how the board gets the correct address. I think this could be a problem.
How much notice do you want them to give before the 5 years is up?
I would say 90 days.
Well, it would need to be more than 90 days because otherwise they can't meet they won't be able to meet the criteria to renew their license.
180 days.
That would allow them to meet one of these criteria to renew their license.
It would be a reinstatement program.
Subsection D, and say something like, the board shall provide 180 days notice to an RN or APRN whose license will be in inactive status for a period of 60 months from the initial date of inactivity to provide notice to such nurse that he or she may be subject to a requirement to complete a reinstatement program prior to restoration of his or her license. Such notice may be provided by electronic means. Is that good?
Okay, has everybody heard the amendment? Okay. Representative Henson.
Thanks. I think I'm a little confused about the amendment because if I was getting that notice from the board, I think, and I was in an active nurse and inactive status, I would think that I had to do something within the 5 years elapsed, as opposed to the fact that I could be inactive for 10 or 15 years. Because basically,
it would notify them that after 60 months they have to take a reinstatement course.
I understand, but it doesn't. Again, I'll go back to the fact I think we're confusing an issue. I really and truly do.
Let's just, okay.
I mean, my feeling is I'm not in favor of the amendment.
Okay.
But I'll go back and say if I was getting that, I would think that even if I wanted to stay inactive, I was going to have to do something. And are you trying to say someone has to do something if they want to stay inactive?
Representative Dobbs.
Thank you, Madam Chairman. My question was, do we want to provide in the language that Betsy has just written that the notice will be given to the address last given to the board by the nurse or the email as they request?
So the nurse would elect whether they got it electronically or by mail?
And it would be sent to the last known
Not that they
address.
were elected. So it is a nightmare. Okay. Representative Drenner.
Chairman Rogers, I guess I'm, with all deference in advance of my question, I don't understand why we need to remind them of something as important as their nursing license.
Yeah, where is Sean Jurgensen in personal responsibility when we need him? Representative Jurgensen, who says his personal responsibility.
I don't understand that, because if I wanted to practice nursing, I would be up on my license and would know when it was going to expire. It's just like my driver's license.
Well, just speaking from experience, I've done this on another board, and you file it away and you miss a date. I'm just trying to leave an opportunity for an inactive nurse, he or she, to get a courtesy notification if he or she has any interest in doing so.
Okay, just so people will know, we have rules in 10 minutes.
Okay.
10 minutes.
Rules in 10 minutes, yes.
So, Betsy, are you ready with the amendment?
Sure. You want me to read the whole thing again?
Right. Okay, everybody listen up.
Okay, new subsection D after line 55, the board shall provide 180 days notice to an RN or APRN whose license will be in inactive status for a period of 60 months from the initial date of inactivity to provide notice to such nurse that he or she may be subject to the requirement to complete a reinstatement program prior to restoration of his or her license. Such notice may be provided by electronic means or by United States mail at the last known address of such nurse. Or how about to the last known?
Okay. All right. We have the amendments. Everybody understand the amendment? Okay. All right. Do I have a motion? Okay. Pardon? Okay. We have a motion and a second. Everyone in favor of the motion, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. Everyone opposed? Okay. I think the ayes have it. And the amendment is same. Okay, we have the amendment now. Where do we stand on the bill? Do we have a motion on the bill? Okay, we have a motion to pass and a second. All right. Any further discussion on the bill? Seeing no further discussion, everyone in the favor of the passage of House Bill 368 as amended, say aye. Anyone opposed? No? Okay, all right. I think the ayes have it. The other bill has been pulled from the day. We are adjourned.